yours.
The Kosovo Specialist Chambers is now in session.
Be seated. Good morning and welcome, everyone. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Gucati&Haradinaj.
For the appearances, Ms. Polici.
Good morning, Your Honor. For the SPO, today we have legal intern Helena Kruger. The remaining members of the SPO remain the same.
Thank you. Mr. Rees? Or Mr. Bowden? Who's speaking?
Your Honour will see that Mr. Rees appears remotely. I'm accompanied in court by Ms. Stevenson, Mr. Joseph Bowden and Ms. Wigmore.
Thank you. Mr. Cadman?
Good morning, Your Honour. I appear with Mr. Solomon this morning.
Thank you. Today we will discuss the next steps in the proceedings. On Friday, we heard the last witness of the Haradinaj defense. At that time, neither defense counsel was ready to close his case as a Rule 102.3 matter was still pending. The panel wants to underline that a pending decision on disclosure does not prevent the defense from closing its case because it does not pertain to calling additional witnesses or presenting more evidence. This is consistent with our ruling on 8th November 2021 at pages 2030 and 2031 of the transcript. To permit a defense case to remain open for every possibility of future disclosure would make progress in the proceedings unworkable. That being said, in the current situation where a request was already pending and given the very short deadline set by the panel, the defense was permitted to have additional time before formally closing their cases. On Friday, 28 January, the panel rendered a decision on the item 205, granting the SPO's request not to disclose this item. Is the defense ready to close his case at this time? Mr. Rees?
Your Honour, no. Can I raise one matter in relation
Can't
to...
hear you, Mr. Rees.
Oh. It was working moments before we came into court.
I'm sorry. Hold on. We've been through this before. Okay, Mr. Rees, sorry.
Your Honour, you can hear me now, is that right? Very good. Your Honour, there is one matter in relation to the decision F00541. I propose a way forward, which I hope means that we can deal with this expeditiously, Your Honour. I do seek leave to appeal that decision and or a decision to reconsider under Rule 79. In the first instance, can I deal with timing? I'm conscious that under Rule 9 of the rules, there is a very large degree of flexibility afforded to the trial panel on timelines. I'm also conscious that under Rule 75, Sub-Rule 2, there is a discretion of the trial panel to allow oral submissions to take place on submissions that are relatively short and not factually complex. My proposal, Your Honour, is that I make an oral application for leave to appeal that decision now. I can do so very quickly.
That's your intention to appeal orally at this time, is that correct?
Yes.
All right, and does the prosecution have a position on this?
The prosecution would object to the defense request for leave to appeal. We don't mind for them objecting orally at this time.
No, I'm asking you, do you have any objection to them orally filing their motion at this time?
No objection, Your Honor.
Okay, and Mr. Cadman, do you?
I have discussed this with Mr. Rees already. We were seeking leave to appeal the decision as well.
You will join in. You will join in
I
that.
will, yes.
All right, Mr. And will the prosecution have any problem responding at this time?
Like to have the benefit of hearing the arguments of the defense, and we were not provided any notice, so I believe we will not have any problem in responding at this time, but I would
We'll
like
see.
to
Okay.
hear first. Yeah,
All right.
thank
Now, before submitting your oral motion, is there anything else you need to have decided?
No, thank you. I can make the submission at this stage now, Your Honor.
Go ahead.
So, Your Honor, we seek leave to appeal the following two issues. The first issue, did the trial panel err in refusing disclosure to the defense of material which in their stated view demonstrated matters which were adverse to the defense submissions on entrapment? The second issue, in the absence of disclosure, was the trial panel wrong to draw conclusions from the material which were adverse to the defense submissions on entrapment? The two issues refer to paragraph 20 of the ruling F00541. As by way of background, both the defense for Mr. Gucati and the defense for Mr. Haradinaj raised the prospect that item 205 may be capable of demonstrating failures of the SPO to take adequate investigative steps. The emphasis being on the word may, because as acknowledged by both the Gucati and Haradinaj defense and indeed by the trial panel, we hadn't, of course, seen item 205 or its contents. So we simply drew the trial panel's attention to the possibility that the material may be capable of demonstrating failures on the SPO's part to take adequate investigative steps. At the outset of paragraph 20, the trial panel observed that item 205 did not contain any information or evidence that would suggest any investigative shortcomings on behalf of the SPO. Paragraph 20, however, did not stop there. It continued and expressed the following conclusion on the material, that, in particular, the interview of the third person by the SPO and the questions posed by the SPO investigator suggest that the SPO is taking investigative steps which appear to be reasonable and professional in the circumstances, including the evaluation of the credibility of the information received from the author of items 203 and from the individual interviewed in item 205. That is a conclusion on material that the defense have not seen or been able to make submissions on, which appears on its face to be adverse to the submissions that have been and will be made on entrapment. In the absence of the material, it is frankly impossible for the defense to understand the comments or put them into any context. I'm conscious that in an application for leave to appeal, it's not the position to argue that there was such an error, but the defense have consistently drawn the trial panel's attention to the case of Edwards and Lewis and the United Kingdom before the European Court of Human Rights, the judgment of the 27th of October 2004, at page 17 in particular, in which the European Court made it clear that the accused ought to have access to all material that's put before the tribunal of fact, which may be relevant to the plea of incitement, including material which may be adverse to the defendant's positions on it. The order otherwise would not comply with the requirements to provide adversarial proceedings and equality of arms and lead to a violation of Article 6 of the Convention. Those two issues, we say, are appealable issues. They are not abstract or hypothetical. They derive directly from the decision. They significantly affect both the fair and expeditious conduct of the proceedings and the outcome of the trial, and immediate resolution by the appeals chamber may materially advance proceedings. We say that because we are at a critical point in the trial. This is the last opportunity for the defence to address any prejudice that may arise from adverse conclusions drawn by the trial panel, from material that has not been shared with the defence, and the defence have been unable to make any submissions on its content. We do therefore seek leave to appeal the decision, or in the alternative, we say that the trial panel could reconsider its decision under Rule 79. That provides a power to reconsider where a clear error has been demonstrated and reconsideration is necessary to avoid injustice. We say that there is a clear error in the decision in that the trial panel drew a conclusion from material which had not been shown to the defence, which was adverse to its submission on entrapment, and that reconsideration of the refusal to disclose should be undertaken to avoid the injustice of that conclusion being allowed to go without the defence having an opportunity to challenge, address, or put otherwise into context. Those are the two submissions I make, Your Honour. Thank you.
Thank you, Mr. Rees. Mr. Cadman?
The Haradinaj defence joins those submissions and doesn't add anything further at this stage.
Thank you. I will ask one other question of the defense. Other than that pending matter, neither of you have any other witnesses to call. Is that correct, Mr. Cadman?
That is correct, Your Honour.
And Mr. Rees?
That is correct, Your Honour.
All right. So depending on the ruling that we will make, and we will make it in writing either later today or by tomorrow, you will be asked to close your case officially, as I said, depending on which way the ruling is. Understood?
Understood, Your Honour.
Understood, Your Honour.
All right. Thank you very much.
Yes.
I'm sorry. Now, Ms. Bellici, you may be heard.
Yes, we'll articulate our objections to the defense request very briefly today in court. So in relation to the first issue that has been highlighted by the Gucati defense, we submit that the defense simply highlight disagreement with the reasoning of the trial chamber, and no error has been shown in any way. As to the second issue, we observe that the issue does not arise from the trial panel's decision. The Gucati defense actually challenges the statutory framework that governs this court by arguing that not showing the item, the disclosure of which is being challenged, would be against supposed regulations or statutory framework. Actually, rules 102 and 108 of the rules expressly provide for the procedure that has been followed. So it's not a challenge to the decision, but a challenge to the rules. Finally, in relation to the possibility that such an appeal advance the proceedings, the prosecution observed that in light of the late stage of the proceedings, the evidentiary case is finished for all parties. An appeal, an interlocutory appeal at this stage would not advance, but actually delay significantly the course of the proceedings, which the SPO advocates instead should be concluded as expeditiously as possible. Thank you.
Thank you. We will consider the request for certification fully submitted orally, and we will make a decision as soon as possible, and we will expect some decision. We will give directions as to further proceedings thereafter in our oral decision. We will continue with the submissions yet today and take them knowing that this certification request is in hand. Excuse me. So the panel will hear submissions on what comes next. We set out our questions in an agenda filed last week in filing F527. Written submissions have been received from both defense teams, so today we will go through the relevant questions. We want to start with the agreed facts. The panel notes that the Haradinaj defense indicated in its written submissions that it adopts the 13 initial facts agreed between the Gucati defense and the SPO during the pretrial stage. Mr. Cadman, does this mean that you do not adopt the additional fact agreed upon between the Gucati defense and the SPO and reproduced in the Gucati bar table motion?
Your Honour, there may be some confusion. My understanding is that we were adopting the facts that have been agreed between the Gucati team and the SPO. My understanding was that we were agreeing the facts as requested that have been agreed between the Gucati team and the SPO in their entirety.
So that is the additional.
Yes. Yes.
Sorry. The Gucati defense also indicated in its written submissions that it adopts the three facts agreed upon or agreed between the Haradinaj defense and the SPO during the pretrial stage. Both defense teams also indicate that the agreed facts can become public and that no further facts have been agreed to. The panel is grateful for these submissions and takes note of the jointly agreed facts. Ms. Bellici, anything to add to this, and in particular, what are your submissions on the classification of the one additional fact agreed upon?
It can be public in our view, Your Honor, and we have no additional matter to raise on this point. Thank you.
Thank you. We'll take note of this in due course. In the agenda, we invited the parties to consider the submission into evidence of certain material which was either used in court but not tendered or was listed by one of the parties but not used. There were three documents, DHG 0075 to DHG 0081, which is a 2014 statement of the SITF Chief Prosecutor and was on the list of exhibits on the Gucati defense. Next are portions of the ICTY judgment in the Haradinaj case, and next the portions of a Kosovo court judgment dated 10 August 2006 used by the SPO during cross-examination. This has ERN number SP0E 00248303 to 00248304. The panel made this invitation as a first step under Rule 132 of the rules. The panel notes that a part of the ICTY Haradinaj judgment was admitted into evidence on Friday. The Gucati defense submits that it does not wish to tender the statement of the Chief Prosecutor and that it opposes the admission of the Kosovo court judgment. The Haradinaj defense submits that it does not anticipate presenting any further evidence and does not advance any submissions in respect of these items. Does the SPO have anything to add on this?
Your Honor, the SPO has conveyed to the defense already on the 21st of January 2022 the willingness to have all these items admitted into evidence. We didn't hear back until last Friday. We maintain the same position, and as to the judgments that have been read in court, the SPO position is that the portions of those judgments are on the record, and that if the admission of the judgment is necessary to confirm that the portions of the judgment have been accurately quoted and that the judgment actually exists, this judgment should be admitted into evidence. Thank you.
Mr. Reese, anything to add?
Only this, in relation to Ms. Bellici's last observation about parts of the judgment from SPOE 00248303 to 00248304. Of course, questions by Ms. Bellici do not amount to evidence. The only evidence that arises out of putting those parts are the answers of the witness. We do not seek submission of the 2014 statement of the SITF Chief Prosecutor. It was not used or tendered with any witness. As we understand it, paragraph 6 of the Haradinaj judgment of the 3rd of April 2008 has already been admitted by Your Honours by oral order on Friday. And we've set out our position in relation to that, the judgment and the parts of the judgment, referred to in the Prizren District Court, matter P number 85, 2005. A careful examination of that passage reveals that only the first sentence relates specifically to that case. And indeed, the comment related specifically to those individuals that gave evidence in the case of number 85, 2005. The remaining part of the passage read by Ms. Bellici was simply the recital of a quotation from another case from the ICTY ITO 366T. The defence, we've had no opportunity to challenge whether either statement was accurate as to circumstance in 2005, 2006, and we make the submission that neither statement in any event can fairly be said to be probative of any environment of witness intimidation in Kosovo in September 2020, which is the time with which we are, of course, concerned.
Thank you, Mr. Rees. Mr. Cadman, anything to add?
Nothing further to add.
All right. Anything from the panel? Any questions? All right. The panel will decide in due course whether to exercise its prerogative under Rule 132 and proprio motu admit these items as additional evidence not produced by the parties. Excuse me. Moving on to the next topic, the panel notes that the SPO has already indicated on Friday that it will probably not intend to seek leave for rebuttal evidence. Ms. Bellici, is this still the case?
Yes, the SPO will not tender any evidence in rebuttal, Your Honor. Thank you.
Thank you. Since the SPO does not intend to call evidence in rebuttal, the question whether defense intends to call evidence in rejoinder becomes moot. Let's move on to the final trial brief estimates. At the defense preparation conference, all parties indicated a tentative estimate of 3 weeks from the closing of the evidentiary proceedings for filing their final trial briefs. In their written submissions, both defense teams revised their estimate and request 30 days from the closing of the evidentiary proceeding to file the final trial briefs. The panel notes that 30 days is the maximum time limit provided by Rule 134.b. The defense submits that it revises its early estimate because of significant additional expert and technical evidence has been heard by the panel as a result of the Court of Appeals panel decision. In this regard, the panel has 2 points to make. First, the expert evidence heard was called by the defense, and therefore it must have been aware of the scope and expertise of its own witness. Second, we note that the estimate provided by the defense was given at the defense preparation conference before the summary of the decision to exclude the testimony of Mr. Reed was read into the record. With this in mind, we would like to hear from the defense as to what was so unexpected about the expert witness evidence heard and that it now changes these estimates. Mr. Rees?
Firstly, Your Honour, our submission was not to request 30 days for the filing of the trial brief post-closing of evidentiary proceedings. We did request a longer period than 21 days, up to the 30 days, and we have taken a similar stance by requesting more time in relation to the shortened period for the hearing of closing statements between the filing of trial briefs and the hearing for closing statements. I'll come back to the specific proposal in due course, Your Honour, but what we invite the court to do is to consider setting down a slightly later tentative date for closing statements and then work backwards, as it were. In relation to the request for a longer period than 21 days, we do stress that On the 2nd of December, that 21 days was a tentatively proposed timescale. It was proposed initially by the SPO without any notice being provided to the defence, and we agreed at that stage that it may be possible to deal with it in a period of 21 days. It is certainly right that at that stage, Your Honour, the closing of the evidentiary proceedings was envisaged to be the 17th of December. That closing date was pushed back later on the 2nd of December to the 17th of January. It's then been pushed back to the 28th of January, and we, of course, have passed it now. We are a considerably longer distance away from the beginning of the evidence on the 18th of October than all parties anticipated that we would be as of the 2nd of December. That requires a greater degree of returning to the transcripts and analysis and recall, as it were. We submit that in those circumstances, requesting a slightly longer period than the 21 days tentatively put forward on the 2nd of December is appropriate. Your Honour will know from the submissions that we have requested that a new tentative date for closing statements to be considered for the 14th of March. That is not a considerable extension on the earlier tentative target date of the 1st of March. And we submit that if the matters were extended by that 2-week period, that would be both proportionate, it would be reasonable, and it would allow us some additional time, not the maximum periods that the rules propose at all, but some additional time to deal with preparing the final trial brief and then preparing closing statements so that we can respond to whatever is in the prosecution final trial brief.
Mr. Rees, I will ask you a question, and I'll later on ask it to Mr. Cadman as well and to the prosecution. From the 1st, or from the last day of February until the 14th of March, are you available for that entire period in case we pick a day in there?
Can I just check for a moment?
Yes.
Your Honour?
You can be checking also, Mr. Cadman.
I do have another professional commitment in the week of the 7th, Your Honour.
All of those 2 weeks are available except the 7th.
Yes, so the week of the 28th of February, and then the week of the 14th.
Okay. Just trying to leave us enough room to maneuver. All right, Mr. Cadman.
If it assists, Your Honour, very quickly, if it assists, I'm also available the following week, the week of the 21st of March.
That may be out of reach. Mr. Cadman?
Your Honour, I'm not available the 14th to the 18th of February. And I'm not available the 28th of February, but I am available throughout March.
I think originally we're scheduled for the 28th of February.
Well, I can make myself available for that one day.
Okay.
I'm just indicating what my current commitments are, Your Honour.
Your Honour, the SPO's position is that there has been no change in circumstances since the estimate that were provided in December that would justify an additional extension and prolongment of these proceedings. As the SPO argued from the outset, the factual issues in this case are really straightforward. The legal issues have been extensively addressed, both in written and oral submission. The defense is well resourced, and the arguments that they have provided for requesting an extension are unsustainable, in the sense that the scope of the evidence that has been presented is exactly the scope of the evidence that was supposed to be presented according to the defense estimation. The fact that it has been spread out in a longer period of time upon defense requests for delays of the proceedings, for the unavailability of the defense, is no justification for a further delay of the proceedings. The SPO position is that the matter should be resolved as expeditiously as possible, especially in the interests of the accused. So we will maintain our position that the parties should be ready to file their final briefs within 21 days from the closing of the evidentiary proceedings, and that the closing statements can be held within a week from the filing of the final briefs. Thank you.
And you have no restrictions on any of the other dates that we were talking about?
The SPO will be available at any time.
Thank you. So, thank you. We will decide this in due course. Mr. Cadman, go ahead.
I wasn't asked if I had any submissions. Obviously, I don't want to repeat what Mr. Rees has already said. Our position is the same. When we gave the indication at the Defence Preparation Conference, it was an anticipated date that we wanted to accommodate. A lot of matters have occurred since that time. What we are requesting is not a substantial extension. And just to be clear, we are not requesting additional time to file our final trial brief on the basis that we are not available. That's not the reason for making that. So Ms. Bellici, referring to the resources of the defence and our availability is not something that the trial panel should take into account. It is mere that we gave an anticipated indication. We have revised that, and the request that's being made should not be considered to be unreasonable.
Thank you, Mr. Cadman. I didn't mean to skip you either. I just thought you were making the same submission. So we will decide this, as I said, in due course. In any case, we remind everyone that written submissions in the final trial brief should be focused. They should concentrate on the facts, issues, and circumstances relevant to the cases of the parties, and avoid lengthy recitations of the procedural background and or verbatim citations of laws or precedents. And political statements should be, as we've said many times, should be avoided. Now, as to closing statements, at the Defense Preparation Conference, all parties indicated a tentative estimate of 1 week from the filing of the trial briefs for the closing arguments, and I know we've spoken about this briefly already, but in their written submissions, both defense teams revised their estimate. The Haradinaj defense requests 14 days, and the Gucati defense asked for up to 21 days from the filing of their final trial briefs. And once again, the panel notes that 21 days is the maximum time limit under Rule 134, Part D. Before asking the parties about their reasons for their estimates, the panel reminds everyone that closing statements should avoid repeating submissions already made in the final trial brief and focus instead on addressing the opposite side's arguments and fleshing out those points not already made in writing, and that the court panel may well have questions to be answered during that time period as well. Ms. Bellici, how long do you need for the closing statements?
Our previous estimate was 4 hours, Your Honor, in terms of presentation of the closing statements. We anticipate that we can maintain this time estimate unless there is a need to respond to unexpected matter raised in the defense final briefs.
Thank you. And Mr. Rees, you can address any of your submissions on this point at this point.
So firstly, in relation to the time requested between filing of the final trial brief and the closing statement, we haven't asked for the 21 days. We've asked for slightly longer than the 7 days. And really, I've already made the submission that I invite the court to look at the week of the 14th of March for closing statements and then work a timetable backwards from the 14th of March for filing of the trial brief. In relation to the time required, we have estimated 9 hours. The prosecution estimate 4. we have estimated that on the basis that inter alia, we will need to go through some of the evidence that hasn't yet been formally gone through. So, for example, I know the trial panel has lengthy transcripts from interviews and the press conferences. And the way in which the prosecution presented the case didn't take the court through that. There's aspects of that evidence that I will wish to take the court through in my closing statement. So the estimate I've given, we think is a fair estimate. I will, as I've always done with my estimates, seek to better it in the event. But I request being allowed up to 9 hours to make the statement.
Sorry, we may have some questions about that. Mr. Reese, did you have your hand up? Did you have something else?
Your Honor, only that I could see you addressing the court, but I couldn't hear you.
That was my fault again. Go ahead, Mr. Cadman.
Your Honour, we've indicated how much time we believe at this stage we would require. Of course, I don't want, again, a common theme in this case, I don't want to go over material that Mr. Reese is going to mention, so we will coordinate as much as we can, but we have indicated up to half a day. Certainly no more than 2 sessions would be required. No more.
No more than 2 sessions.
No.
Right. Well, as you know, we have considerable discretion on this issue, and we will consider it and make an order in due course. We go to the next topic. Pursuant to Rule 6, or Paragraph 6 of Rule 159, if the panel finds the accused guilty of one or more offenses, it must hear the parties on whether appropriate sentence should be imposed with the pronouncements of the trial judgment or in a separate procedure. The panel reminds the parties that the decision whether or not to impose a sentence with the pronouncement of the trial judgment is within the discretion of the panel. Given that this decision affects the content of the final trial briefs and the closing statements, the panel finds it appropriate to receive submissions from the parties at this point. This is, of course, without prejudice to the panel's determination of whether the accused are guilty or not guilty of any of the counts. The panel notes that the Gucati defense already submitted that the panel should proceed with the so-called bifurcated procedure unless it found the accused guilty of one or more crimes and was of the view that the accused already served the appropriate term of imprisonment by the date of the pronouncement of the trial judgment. And our first question, Mr. Reese, is how do you expect the panel to know at this point whether your client is to be convicted, and if so, what sentence he should get? Or do you suggest that we do not decide now, or whether to separate the two procedures?
Obviously, the submission I make at the invitation of the trial panel is without prejudice to my submissions that Mr. Gucati is not guilty of any offence, in the same way as it is without prejudice to the trial panel's eventual decision on judgment. The fact that we have been asked to address the prospect of a conviction on one or more offence, in part demonstrates, frankly, how uncomfortable it is for defence counsel to address sentence in this way before judgment has been entered. And that is, in part at least, our objection to to the prospect of being requested to make submissions in mitigation ahead of any judgment. But that is not the only basis, although I urge the trial panel to give fair consideration to that submission. Our primary basis is that the bifurcated approaches, as Your Honour has described it, ought to be adopted. And in particular, although I do not suggest that there are no circumstances in which the panel could exercise its discretion to deal with sentence immediately, and I have proposed one possible scenario where that may be appropriate. And another scenario might be where a defendant faces a single count with a single basis of liability alleged by the prosecution, so that one can predict what defense counsel may be dealing with in the event that the trial panel convicts on that single count and that single basis of liability. But we are not facing that situation by any means. We're facing, Mr. Gucati faced an indictment with 6 counts. And as your honours have observed previously, multiple alternative bases of liability put forward by the prosecution. In relation to the offences themselves, offences originating from the Kosovan criminal code, the precise scope of those offences is yet to be determined, with detailed submissions as to what are the essential legal ingredients for those offences having been made previously in the case, including at the half-time stage, and with those essential legal ingredients still to be determined and identified by the trial panel, we will not receive the trial panel's decision on the scope of each of those offences until we receive the trial judgment. So there is a uncertainty in that regard, as well as with regard the number of counts and the alternative number of bases of liability alleged. We submit that it is neither practicable nor fair for the accused, in the circumstances of this case, I do not say in every case, but in the circumstances of this case, to be asked to prepare abstract submissions in mitigation in advance of any trial judgment, identifying which count or counts and upon which basis or bases Mr. Gucati might fall to be sentenced, if he falls to be sentenced at all. We only raised the alternative scenario in paragraph 24 of our submissions on the basis that if, when the trial panel post closing statements is reaching the end of its deliberations, and if it finds at that stage that the accused was guilty of one or more offence, and if at that stage, without hearing anything further, it was of the view that, taking into account the time the accused had already been detained on remand, that he or they had or will have, by the time judgment is pronounced, have served the appropriate time of imprisonment, then of course we would not in those circumstances object to the trial panel at that stage ask taking further time to hear submissions in mitigation and then deal with sentence, because that would only delay the time in which the accused were detained beyond that which was appropriate because of the trial panel's previous view. But I concede that is a hypothetical situation we've raised. We've raised it because we were invited to consider how we deal with the hypothetical situation as it is at present, that Mr. Gucati may be found guilty of one or more offences. Our primary submission is that, in light of the fact that Mr. Gucati faced an indictment with 6 counts, multiple bases of liability in relation to offences, the scope of which is at present uncertain, the trial panel ought to proceed in accordance with rules 162 and 164. That's the submission on behalf of Mr. Gucati, Your Honour.
Thank you. Mr. Cadman?
I fully concur with what Mr. Rees has presented and do not need to add anything further.
Thank you. Ms. Polici?
Thank you, Your Honor. The prosecution notes that pursuant to Rule 159.6, the identification of the determination of the appropriate sentence at the time of the judgment is the rule, while the bifurcated procedure is the exception. In our submission, the defense has not highlighted circumstances specific to this case that would justify bifurcated proceedings. considering that the fact that there are multiple counts of multiple modes of liability is something to be normally expected in criminal proceedings before international courts, and it's no exception. The facts of this case are particularly straightforward and simple, and in this light, a bifurcated procedure is not necessary. The one matter that the SPO would like to highlight is that in the framework of the sentencing procedure, the SPO does intend to submit the relevance of the official notes on contact with witnesses as previously anticipated, both in oral and written submissions, which have been declared inadmissible for the purpose of the trial judgment because falling under rules 153 to 155. The SPO notes that Rule 162.1 of the rules permits the party to submit at the time of sentencing material, any relevant information that can assist the panel in determining the appropriate sentence, and that the principle of orality is also different at the time of the sentencing procedure according to Rule 162.4, which provides that sentencing should be done via written procedure unless otherwise provided. So the only reason why the prosecution would consider that a bifurcated procedure is necessary in this case is if the trial chamber was not willing to hear submission on these materials together with the judgment. I would request instead a bifurcated procedure for the SPO to provide submission on these particular documents. Thank you.
Thank you, Ms. Belici. Anything from the panel on any subject? Judge Mitro?
Thank you, Judge Smith. Mr. Rees, and I will turn to Mr. Cadman in a second. I have two things that I would like you to clarify, if you may. The first one is in relation to the length of the proposed oral submissions. I think you mentioned 9 hours that you would wish to be granted, and you've indicated that the main reason for this is the fact that you would like to expand upon certain aspects of the case exhibits or otherwise that to your mind have not been explored adequately during the trial. What I want to ask you is what of that exploration could not be included in your written submissions? Is there any particular reasons why you would wish to present that information only at the oral hearing? Is there anything preventing you from presenting, at least in part, or maybe even in its totality, these submissions in your written submissions?
Your Honour, we will, of course, endeavour to keep both our written submissions as concise as possible and our oral submissions as concise as possible. But there is a value to making oral submissions, and there is a value to the principle of orality, which I would wish in the presentation of my closing statement to take advantage of. And it does seem to me that on behalf of Mr. Gucati, it is appropriate for me to both take some time to argue some of the legal principles that we will set out and have set out previously in writing, and we will, again, taking the presiding judge's exhortation to heart, set out in our pre-trial brief, but concisely, without reciting at length passages. But I will wish to argue some of those principles and submissions that we make on the law during the course of my closing statement. And I will seek to draw the court's attention to parts of the evidence when I do so. And it does seem to me that it is an important matter, it's an important part of the principle of orality, that I do that both on my feet before Your Honours, where Your Honours are able to make interventions like Your Honour has done now and has done throughout the trial. And it gives me the opportunity to answer questions from Your Honour directly. And have Mr. Gucati able to see that take place before him, rather than the matters being simply condensed into a written filing. I'm well aware of the trial panel's preference for oral submissions rather than lengthy written documents that simply recite matters that are already set out. And I wholeheartedly endorse that preference and therefore wish to address the trial panel at some length, but with an eye, as always, and I hope that the trial panel will concede this on my part, that I have tried to be concise and direct and not waste any time at all.
Well, yeah, Mr. Rees, I can put that part of your mind at rest, that no one feel or thinks that you are wasting anyone's time, and no one wants to take away from you the possibility of oral submission. We want to give you that opportunity because it is, we see, to your benefit. My question is really whether there's anything that you wish to put orally that cannot be placed in writing, and it's really a matter of balance that I'm asking you to address, not one of choosing between one or the other. So asking perhaps more question again, is there a concern on your part that there are things pertaining to this case, aspects of the case that cannot, at the very least, be prefaced in your written submissions and kept perhaps to a shorter version orally?
Your Honour, certainly our final trial brief will preface what I intend to say in my closing statement. I can assure the court that. I also accept Your Honour's categorization of the issue as a matter of balance. It is a matter of balance. And in my submission, it's a matter of balance that it's for defence counsel to strike, to consider where the balance falls, and take a tactical decision as to how I seek to employ on Mr. Gucati's behalf the material as best I can. It is a matter of balance. I will endeavour to keep both the final trial brief as concise as possible, as I will do with my closing statement, Your Honour. But it's a balance that, in my respectful submission, it is for counsel to strike.
Well, I won't say anything about that last proposition, Mr. Rees. I'll leave it to you. But the second question that I have for you has to do with, I just want to be sure that I have a proper understanding of your submission on the bifurcated or not bifurcated process. Am I right to understand that the crux of your concern is that you wish to have a clear understanding of the nature of a conviction if a conviction is entered before you make your submission? In other words, your submission on that point are not linked to any wish on your part to call any evidence in relation to that issue. Is that correct? You want clarity if a conviction was to be entered as to the nature of our decision. Is that correct?
I would wish to have clarity as to what has to be addressed on behalf of Mr. Gucati in the event, if it is the event, that he is convicted on any offence. That may, for example, Your Honour, once we, again, if dealing with the hypothetical situation, Your Honour, that there is a conviction or convictions, once the basis is clarified, that may lead to us calling further evidence in mitigation, because we will have an understanding of what it is that needs to be addressed for the purposes of sentence. I simply, in an indictment with 6 counts and multiple bases of liability, and in relation to offences, the precise scope of which are not clear at present and are only to be clarified by the trial judge's decision, in my submission, it is unfair for us to try and draft both submissions in mitigation and to consider whether we wish to call any further or reduce any further material in mitigation on the hypothetical basis of a conviction in relation to 1, 2, 3, 4, 5, or 6 counts on any numerous alternative basis of liability on 1, 2, 3, 4, 5, or 6 counts. I frankly, Your Honour, do not have the prescience to look ahead and forecast the matter in that way, or indeed to forecast how I might wish to deal with such matters in mitigation. We're not dealing with a more straightforward matter in which it might be appropriate, it might be very simple to do that. We are not in that scenario in this case. So if in short, Your Honour was asking me, do I envisage, if we are faced with having to mitigate, calling any further evidence or reducing any further material? My answer at this stage is, I simply do not know, Your Honour, because I do not know upon what basis and on what counts the trial panel may enter judgment, and what I might seek to do to deal with those matters in mitigation. Can I say this in relation to the submission from Ms. Bellici? The trial panel has refused to admit the official contact notes, and without specifying year ends, I hope the trial panel will understand, as I did, what the notes that Ms. Bellici was referring to. They have not been admitted in evidence. They cannot be admitted before the trial panel pronounces judgment. If, as far as I understood the SPO submission, which is that they would wish to invite the trial panel to take such matters into account in relation to sentence, that can only be done under Rule 162, Rule 1, if it can be done at all under the bifurcated procedure, as it were. Now, I'm not inviting in due course for that to happen, but the submission that Ms. Bellici makes, in effect, is that, and can only be, that a bifurcated approach should be taken. And really, it comes back to the position at the moment we have an indictment with 6 counts, multiple bases in relation to offences, the precise scope of which is unclear. And I would wish to reserve my position, as the SPO apparently seeks to do, to submit further material if judgment was pronounced against Mr. Gucati, and to assist with mitigation.
One last thing, Mr. Rees, and thank you for your submissions. I think we'll turn to the prosecution in a second to ask them to clarify this, maybe. But I understood Ms. Bellici's submission to be that the non-bifurcated process is the norm and bifurcation the exception. Now, assuming this to be the case, Mr. Rees, and assuming just for the purpose of my question, can we take it that in that respect you would have called what evidence you consider to be relevant in case a conviction is entered? What would you say to such a submission if Ms. Bellici is right about her legal proposition?
Well, Your Honour, can I begin by challenging the proposition that Ms. Bellici makes? I do not accept that it is the rule that sentence shall be imposed under 1596, and that the bifurcated approach of Rule 162 and Rule 64 are the exception. After all, as far as I am aware, perhaps Your Honour can correct me if I'm wrong, there has been no other sentencing exercise conducted by the Kosovo Specialist Chambers yet. And what is the rule and what is the exception is yet to be determined, perhaps, given that the Specialist Chambers has not yet had to grapple with such matter. And it may not in this case, I hasten to add. What I do note from Rule 159, Sub-Rule 6, is that it simply provides for sentence to be imposed with the pronouncement of trial judgment unless the panel decides otherwise. And it is clear to me from the scope of Sub-Rule 6 that that is a wide discretion. It's simply the only boundary to that discretion is that it must hear the parties on the point. Otherwise, it is the widest of discretions. In other words, Rule 159 Sub-Rule 6 provides for a very wide rule at the panel's discretion, either to impose a sentence with trial judgment or to do so later. In relation to the point that Your Honour asked about, well, hasn't all relevant material been already adduced? Well, the answer to that, Your Honour, is that I do not know, because I do not know at this stage whether Mr. Gucati will be found guilty of one or more offences, and if so, upon what basis. I do not know at this stage, indeed, what are the essential ingredients of the offences that the trial panel are to determine. And it is by no means an unusual concept that for the purposes of considering a trial where guilt or innocence is at stake, there may well, of course, be material that is relevant to the issue of sentence, for example, in relation to personal circumstances, which may be relevant to mitigate sentence, which were not relevant to the issue of guilt or innocence, and accordingly not adduced during the course of a trial. So, one, I do not accept the proposition that Ms. Bellici puts forward. And secondly, I cannot say to Your Honour that all relevant matters that we may wish to put before the trial panel for sentence have been done during the course of the trial. That simply is not how trial and mitigation operate.
Thank you, Mr. Rees. Mr. Cadman, before I turn to the prosecution, anything you want to add?
No, I think Mr. Rees has covered all points adequately. The only point that I would seek to add, specific to the Haradinaj defence, in terms of the balance between the written submissions and the oral submissions, mindful of the time that Mr. Rees has requested, we will obviously endeavour to put concisely as much into our written submissions as we can, and then of course the oral submissions will merely be a summary of what is contained within the written submissions, but we will keep that to a minimum. Now, on the basis that Mr. Rees is granted the time that he is allowed, I may be able to shorten the amount of time that we are requesting from half a day to one session, but a lot of that will depend upon the presentation of the Gucati defence, which I cannot predict at this stage.
I'm grateful. And Ms. Bellici, I mean, anything you wish to respond, in particular to the submission of Mr. Rees on any of these issues? In particular, something that I have to admit was not exactly clear to me, and apparently not to Mr. Rees either, is whether you plan or you propose to rely upon material not tendered in evidence for the purpose of sentencing, or was that a misunderstanding on our part?
Your Honor, yes. In relation to sentencing, is our position that the parties can rely on material that has not been admitted yet, it has not been tendered for admission or has not been admitted. And this is based on Rule 162, I'll tell you in a moment. It's based on Rule 162.1, which permits the party to submit any relevant information that may assist the panel in determining an appropriate sentence. So our position is that within the framework of a non-bifurcating procedure, within the framework of the procedure under Rule 159.6, the parties are allowed to present their submission on sentencing in relation to materials and information other than the admitted evidence. In this context,
so just stopping you there, Ms. Bellici, if I understand it well, and also perhaps for Mr. Rees' benefit, if we were to decide a non-bifurcated process, we would then be seized of an application on your part to have certain additional documents admitted, including the notes that we declined to admit as part of the case. Is that your submission?
It would not be a request for admission of these materials into evidence. It would be a submission of information within the framework of Rule 162.1. So the circumstances that can be relied upon only for the purpose of sentencing do not need to be admitted evidence in our submissions. So within this framework, only for the purpose of sentencing, we would seek to rely on information other than the admitted evidence.
But let me take you to task here a little bit, but do you accept that an aggravating factor, if you were to put one forward in case of a conviction, would have to be established to the standard of proof of beyond reasonable doubt? Do you accept that?
We would accept that, Your Honor. It's the nature of the statutory framework in relation to information that can be relied upon for sentencing purposes, only for sentencing purposes. In this framework, Rule 162.1, as well as the procedure highlighted in Rule 162.4, so that is, unless otherwise decided, sentence shall be determined on the basis of written submissions alone. There is also a derogation from the principle of orality in that respect. We submit that for sentencing only, other information than the admitted evidence can be relied upon.
So in your submission, we can make a finding beyond reasonable doubt on non-admitted information. That's your submission?
Yes. The aggravating circumstances, yes, we agree fully needs to be proven beyond reasonable doubt. Aggravating factors can be dependent on a number of different circumstances. We argue that aggravating factors can be determined based on information other than admitted evidence.
And do you have any authorities other than your interesting reading of the rule for that? Do you know of any courts, any legal system in the world where this is done?
This is our reading of Rule 162.1, Your Honor, and if required, we'll be happy to provide the authorities if necessary.
Thank you.
Thank you.
Ms. Bellici, I would ask you to, just a second, Mr. Reese. Mr. Bellici, I'd ask you to consider the fact that there's some difference between a document that was not admitted and a document that was ruled inadmissible by the court. And that is one of the things we're struggling with your proposed introduction of something that was not introduced by the author, by a person, but is being introduced by a document that somebody else drew up. And that was the problem with the truth of the matter being admitted in the first place. And I'm not so sure it doesn't continue on at the point of sentencing as well. And so that's what we are struggling with. And if you want to make a submission on that, you may.
The submission is simply based on Rule 162.1 and the possibility of relying on other information. For example, the Gucati defense was referring to personal factors as a possible mitigating circumstance. I mean, it's our submission that is not required that the witness comes to testify about the personal circumstances of the accused in order to take into account personal factors as mitigating circumstances. In the same way, for aggravating circumstances, is our submission that Rule 153, 155 do not apply. That was the reason why the specific documents I'm talking about have been not admitted through the bar table motion. And in this light, this is information which might impact on sentencing, and we submit that this can and should be taken into account.
I thank you for that information. Yeah. Mr. Reese, you had one more comment?
Yes, just one. Ms. Bellici says that she relies on Rule 162, Sub-Rule 1. It's very clear to me, at least, that Rule 162, Sub-Rule 1 does not apply where sentence is pronounced pursuant to Rule 159, Sub-Rule 6. It expressly says that. It only applies where the panel decides to proceed in accordance with Rule 162 and Rule 164.
Thank you. We will, oh, I'm sorry. Judge Gaynor has a question.
Thank you very much, Judge Smith. Ms. Bellici, I just want to go back to the meaning of the expression, any relevant information that may assist the panel in determining an appropriate sentence, which is the part of Rule 162 that you're relying upon. Essentially, if a conviction is entered, the panel will be interested in hearing evidence concerning mitigating factors, which are to be established on the balance of probabilities or aggravating factors, which, as Judge Metro pointed out, are to be established beyond reasonable doubt. Now, do you accept that there may be a slightly different approach to the defence and to the prosecution, that it may be that the defence will want to submit written statements which don't necessarily comply with the rules of, with the lex specialis of Rule 153, 154, 155, and they should be permitted to do so. But that, on the other hand, if the prosecution wishes to establish an aggravating circumstance, a different standard applies, because the prosecution may have to comply with the strict rules of evidence in a way that the defence might not have to. Would you agree that that's a potentially reasonable interpretation of the words any relevant information that may assist the panel set out in Rule 162?
No, Your Honor, we wouldn't agree with this position at this stage, considering that there is no differentiation made in Rule 162 in this respect, and that we are not referring to aggravating circumstances that establish, but to aggravating factors, which means circumstances that need to be taken into account in order to assess the sentence which is appropriate in the specific circumstances. So not as a part of the elements of the crimes to be proven beyond reasonable doubt, but as elements to be considered for assessing simply the determination of the appropriate sentence.
But don't aggravating factors have to be proven beyond reasonable doubt? Do you accept that or not?
Yes. And in relation to information that is relevant for sentencing, the proof does not need to be obtained based on the same restrictions that is applied to in relation to Rule 139 in relation to evidence admitted for the purpose of establishing the guilt or innocence of the accused.
Okay, I have no further questions. Thank you.
That is the entire agenda for today. Kinga, am I correct about that? Have we got anything else left? All right. All right, so thank you very much for your candor, for your cooperation, for your submissions. We will do our best to get an order out as soon as possible. Thank you also for bringing your certification request orally. I think that will aid us a great deal in getting this handled expeditiously. We will be in adjournment. You will next hear from us in writing. Thank you.
All rise.